SJC-11591, Commonwealth versus Morin.
Mr. Shaw, good morning.
Good morning, Chief Justice Gants, and may it please the court, my name is Robert Shaw. I'm privileged to appear today on behalf of Aaron Morin. My intention this morning is to address the core aspects of, I hope, several of the issues that are before the court, beginning with the felony murder instructions, and then I'd like to begin by discussing the instruction on conscious disregard, and we'll branch out from there. With respect to the conscious disregard instruction, the fundamental problem is that the judge directed that conscious disregard for the risk to human life can be found if Mr. Morin knew of danger to human life. And let me be very precise about the judge's language. He defined what he called exhibiting a conscious disregard as a robbery having, quote, occurred in a way known to Aaron Morin to be dangerous to human life. And that stands in contrast to the model instruction, which directly states that Mr. Morin must have committed the felony with a conscious disregard for the risk to human life. The model instruction melds together the requirements that it must be the defendant, that he must be committing the felony with conscious disregard to human life. It's not merely knowing that the felony occurred in a way that was dangerous. And to be more helpful, let me focus in on the two basic concepts that are problematic in the judge's language. The first is knowing. Simply knowing of something can be satisfied by somebody who is completely passive, somebody who is in a position to be aware. They might be present, they might not be present, but they're not actively causing a risk to human life, much less disregarding it in the commission of a felony. So knowing of something alone is not the same thing as knowing of something and then disregarding what is known. And that's what the model instruction requires. The second problem with the judge's instruction is this notion of limiting it to danger. Something can be dangerous without posing a foreseeable risk. The law requires that the defendant consciously disregard a foreseeable risk of the actual loss of human life. That's what the case law says. That's something more than knowing of danger. When somebody speeds on the freeway, plays tackle football, there is danger to human life. That doesn't mean that someone who speeds or plays football is consciously disregarding an actual foreseeable risk to the loss of life. So this is really what the problem is. I think this is a fundamental problem with the judge's instruction and his modifications of the model instruction in this case. Now, there are two related modifications that I think exacerbated this erroneous conscious disregard instruction. The first is not only does the judge omit the model's language, which says very simply, very directly, that it must be Morin himself who consciously disregards the risk for human life, but then he adds language that what the jury needs to do is they need to look and see whether Morin exhibited a conscious disregard. The word exhibit connotes appearance from the perspective of another who is looking at Aaron Morin. Somebody can exhibit something without intending it. Somebody can exhibit something without even being conscious of it. So the determination required of the jury should have been focused on Morin's state of mind, his subjective state of mind, not appearance. The other related modification was the judge telling the jury that they need to determine whether conscious disregard, whether the robbery was perpetrated with a conscious disregard. That's problematic because we have a joint venture situation. We have as many as 4 people involved. It's not enough for the robbery to have been perpetrated with conscious disregard. Morin must have himself consciously disregarded the risk to human life. So these two...
So,
Mr. Shaw, I have to say, this, you're focusing in on these 2 points kind of strikes me as nitpicking, because I just think that he didn't mislead the jury. He certainly communicated what he was supposed to communicate, that he's talking, when you use the word exhibit, I mean, how can you find fault with that? He's telling them that they need to be looking at the defendant and what he did.
Well, I think that's really what the Commonwealth would like, is for the court to sort of step back and say, generally speaking, they're okay.
Makes perfect sense to me.
Well, I think the primary problem is the initial problem with conscious disregard. And I think that the exhibit, the word exhibit, and then, not being specific to Mr. Morin in the instruction, those are additional modifications. But I think, when you look at what the judge instructed, it's very clear that what the judge is saying is that in order to find a conscious disregard for the risk to human life, what you need to do is look and see whether the robbery occurred in a way that was known to be dangerous. That is the heart of it. And that simply is not enough.
The robbery is occurring as a result of somebody's action. It doesn't occur in a vacuum.
That's right,
So-
somebody. And the model instruction in the law requires that Aaron Morin consciously disregard the risk to human life. It has to be him. It's a non-inherently dangerous felony. We're not going to hook him on a felony murder, first-degree murder conviction unless he has conducted himself in a way and he himself has consciously disregarded the risk to human life. And that's what the real problem is. Now, branching out from that instruction...
So before you leave that instruction, did the defendant object to the instruction?
The defendant did not object to this particular instruction.
We're dealing with substantial likelihood.
That's right.
And in a context, I mean, isn't it relatively clear that the victim was terribly beaten before Mr. Morin? I mean, the jury would have had to find that Mr. Morin planned it or participated in it through being there, and that when they left him alone with Mello, he was very, very badly beaten.
Well, clearly there was a physical assault. It's not clear whether there was a merger issue, and that was even independent of the felony.
Let's assume he was still alive at the time that everybody other than Mello left.
Right, and there was clearly a physical assault, but we also have evidence that he was alive after that and that he perceived himself to be okay through the statement that he made.
Well, I thought that, I see you keep saying that in your brief, but didn't the judge exclude what the person allegedly said?
Well, the judge excluded the content. The judge didn't exclude the fact of the statement.
So you can't say that he said, "I'm okay."
Well, he's alive and he's talking, right. He's alive and he's talking, and based on what the ME said, the victim at that point, had he been killed or suffered harm enough to kill him during the robbery, he would not have been able to speak.
Of course not.
Right. So, well, I mean, in terms of the strangulation is the point. Okay, so I think that in terms of the substantial likelihood issue, this really becomes a troubling case because it's not at all clear that Morin was even present. If he was present, this was an unarmed robbery and there was a physical assault, but we don't know the extent of that, and then he leaves, and afterwards, assuming that Mello strangled him, he strangled him after the fact. So that's really where the problem comes in. And there, of course, are a number of issues that concern whether the notion that Aaron Morin, by planning an unarmed robbery, could have satisfied the conscious disregard element. Because again, the government concedes that there was no plan to kill anybody. They were just going to grab the drugs and the money and run. It was an unarmed robbery. So if the conduct that we're looking at, and pursuant to the judge's instructions, the jury could have done this, to say that, well, you can base a felony murder conviction on the conduct of Aaron Morin prior to the time the robbery occurs, that is not sufficient evidence for a felony murder conviction in the first degree. Now, there are a lot of other issues, and let me see if I can raise them together, given that they go to this issue of the relationship between the felony and the killing. They go to this critical issue, and this critical issue arises because of Mello potentially strangling the victim after the fact. Notwithstanding that this was a critical issue, the judge added language again to the model instruction, and he tells the jury that, quote, the felony need not be in progress. Now, why is that a problem? Well, that's a problem because if it's not in progress, it's over with. If it's not in progress, it's done. And that is in direct conflict with the requirement under the law that the killing occur during the course of the felony. Secondly, the judge refuses to...
But our instructions make it clear that if you kill in the course of an escape, that is felony murder.
Right, but then again, an escape is part of the progress of the robbery. The progress may be the beginning, it may be at the end, but progress is progress. He adds language saying the felony need not be in progress, and that's what the problem is. Second, it's requested of him to instruct the jury that the killing needs to be in furtherance of the felony. He refuses. Third, there's a request that the killing needs to be the natural and probable consequence of the felony. Again, he refuses.
Right, but it's, I mean, that's put aside in furtherance for now. It doesn't need to be the natural and probable consequence of the felony. I'm not sure what natural and probable consequence is. Many felonies are committed without anybody dying. It's not as if it's inevitable or even likely.
Well, right, and I think that's the concern. Of course, Your Honor used that language in the Caiazzo case just in 2015, and I think that that language goes to this fundamental issue of foreseeability. There is supposed to be there is supposed to be a relationship between the felony and the killing, and these various aspects of language in the instruction and the case law are meant to convey that there needs to be that relationship. And
How about this? He says, as long as the killing of Chad Fleming was connected to an incident to the robbery and occurred at substantially the same time and place as the robbery, the Commonwealth has proved this element.
right, and right.
Why isn't
and,
that sufficient?
Well, because it's very broad. I mean, I brushed my teeth this morning at 5:30 in the morning because I had this argument here today. Is that connected to the argument? Well, in a sense it is. If I go to have lunch with somebody after this argument, is that, and it's downstairs at a restaurant, is it at substantially the same time and place? Yeah, it may be.
Vicious,
But,
right?
well, no, but it's very broad and it's very ambiguous. And for a judge to tell the jury when there is this critical issue regarding, somebody strangling somebody after the fact, that it need not be in progress, that is an issue. So our position is that, to say connected to say incident to, that isn't sufficient. And there was no instruction here regarding foreseeability at all. So there was this critical issue, and the judge was modifying the instructions in a way that went to this critical issue. The final instructional issue I'll address concerns the judge telling the jury through the Zanetti instruction that the predicate felony required for felony murder could be satisfied by what Morin did at the planning stage. So this is coming back to that issue. In other words, that he didn't need to be present during the execution of the robbery. That is a problem because the judge is indicating that there is sufficient conduct for a conviction when they look at what Morin did at the planning stage. But at the planning stage, there was no intention to seriously harm or kill anybody. The government concedes that.
We just need intention to commit the felony.
Well, right, but it's non-inherently dangerous. So Morin needs to do more than have the intention to commit the non-inherently dangerous felony. He needs to consciously disregard the risk to human life when committing the felony and executing the felony. So Zanetti is a very broad, it broadened out the circumstances in which there can be joint venture. And for the judge to say that, you can satisfy the predicate felony by planning or asking or encouraging, okay, this is too broad, it's inconsistent, it's indicating to the jury that they can convict based on facts that are in fact insufficient. And again, this comes back to the same issue with Mello strangling after the fact. It's the exact same issue. If, in fact, this was a non-inherently dangerous felony and there was an assault, the robbers take the drugs and the money and they leave. It's outside of any plan. It's outside of Morin's awareness. And then after the fact, Mello strangles him for whatever reason that may be. There was tension between the two. Mello was highly intoxicated. He was heavily addicted. He was, went into withdrawals when he was interrogated later, as the court knows. If this was outside of Morin's consciousness and awareness and outside of any plan, how can the conscious disregard element be satisfied? So that is a fundamental problem. Now, with respect to the issue about this victim saying, I'm okay, I'd just like to make two brief points about that before I go to the suppression issue. And the first is that I think it's important to recognize that the content of the statement, I'm okay, was significant. And it was significant because it made clear that it was the victim speaking. So it was probative of that, and it was probative of the fact that at that point in time, whatever had happened at the robbery, if we assume that Morin was involved and present when the robbery was executed, that the victim at that point perceived himself to be okay. So this is evidence that's helpful to the defense, and yet the judge is prohibiting it. This is evidence that indicates that whatever happened at the robbery, there wasn't a strangulation or conduct that was capable of killing the victim. Now, the second point I'd like to emphasize is the reason that the judge micromanaged this evidence and really intervened so that the content of this statement couldn't come in. The judge literally expressed the view that if the jury interpreted the statement, I'm okay, as the victim not having been severely beaten during the course of the robbery, that would be misleading. And so that's why he excluded the evidence. Well, that is a judge having a particular view of what the jury should find, and out of concern that the jury might interpret or find evidence that is contrary to what he thinks they should find, he prohibits the evidence. That's invading the province of the jury. So for that reason, that is improper. Now, we then come to the ineffective assistance and the suppression issue.
Right, and I guess the core issue is, if nothing from the statement, nothing from the so-called, or from that statement was admitted in evidence, why do we need to address it? Because it's as if it were suppressed.
Right. Well, what the judge says is that that's exactly right. He even assumes an illegal seizure and arrest of Mr. Morin. He doesn't quarrel with the fact that the police engaged in what was really egregious conduct. He says that there was probable cause to seize the phone. Well, the point is that there was not probable cause to arrest Morin. There was not probable cause to seize that phone, and there was an inevitable discovery. I think that really is the crux of the issue. Was there probable cause to seize the phone? Well, there wasn't probable cause to seize that phone. And by the way, we know there wasn't probable cause to arrest Morin. There wasn't even probable cause to arrest Mello at the hospital. So if there's no probable cause to seize the phone, we have a problem.
Mello wasn't arrested at the hospital.
My interpretation of the court's decision is that it should have been thrown out because by the time he got to the police station, they didn't have probable cause. Well, they certainly didn't have probable cause here. But again, if there's no probable cause to seize the phone, and the phone The seizure of the phone is not unconnected to an illegal arrest and to egregious police misconduct. It arises out of that. You can't just separate that and look at it in a vacuum. It's related to that. In terms of inevitable discovery, the judge says, well, it would have been inevitably discovered, but he doesn't really tell us how or why. Inevitable discovery requires a two-step analysis. The judge is supposed to look first and say, would discovery have been practical as, certain as a practical matter? And then the judge needs to look and say, well, was there egregious police misconduct? Because if there was, then it may be suppressed even though it would have been inevitably discovered. So I think that the judge is just clearly wrong on this. There was ineffective assistance of counsel for not having filed this motion to suppress. It was critical evidence, and so we would ask the court to rule in that manner.
All right, thank you.
Thank you.
Ms. O'Neill, good morning.
Good morning, Chief Justice Gants, and good morning, panel. May it please the court, Mary O'Neill for the Commonwealth. When preparing for today's argument, two words came to mind. One was fairness, and the other was actually a name, Iago.
I'm sorry, was which? Was
Shakespeare's
Iago?
Iago.
Iago,
Yeah.
from Othello. That's
From Othello,
those are the
correct.
first two names which came to mind, really.
Fairness and Iago.
Okay.
The fairness piece speaks to how Judge Kane handled his trial. In terms of my brother's comments and arguments regarding the jury instructions, I would suggest to the court that perhaps a closer reading of the transcripts and the records will show that His Honor hewed closely, if not exactly, to the model jury instructions, as well as to the case law. When he was asked by defense counsel to give an instruction that was from Matchett, that had already been decided not to be used in future cases, His Honor quite rightly said, no, in that case, I'm not going to do that, but I'm open to any other suggestions you might have. And I do point out, the Commonwealth does point out in its brief, that the judge, and throughout the transcript, you can see where he time and again says, what jury instructions do you want? Let's have a jury charge conference. It went on repeatedly. So it's clear that the judge was very cognizant of what jury instructions were required in this case. In addition to that, he gave the right ones. I would echo the comment from Justice Hines regarding the nitpicking piece. It's not even, it's that and more, because there's one example of where he says exhibits, and I would suggest to the court that exhibits is not error in this matter. You will also see regarding that particular instruction that he uses the exact wording from the model jury instructions and doesn't use exhibit. That's set out in the Commonwealth's brief. So time and again, Judge Kane gave the correct instructions. On conscious disregard, he gave them repeatedly. On joint venture, there's several, as your honors have seen, many cases with many transcript volumes, but there are several examples within all the volumes of every single time somebody like a Michael Madison or a Kendra Mello or Bradley, I can't think of Bradley's last name, but in any event, anytime one of those gentlemen testified or lady testified, His Honor, before the testimony, instructed the jury as to what they had to find regarding joint venture before they could accept anything, if they chose to, that the witness said. So fairness. His Honor was scrupulously fair in terms of the instructions given. So I would suggest to the court that there was certainly no error and, of course, no substantial likelihood of a miscarriage of justice based upon any of the instruction arguments brought by my brother. The other piece, and maybe I'm responding more to the amicus brief than I am to my brother's argument right now, but the other piece where I mentioned Iago, in a 33E evaluation, and I'm going to couple that with the idea that the policy argument that's been presented in my brother's brief and in the brief of the amicus, that it's time for felony murder to end. I would suggest to the court that if the court does believe that, and I would suggest to the court that they not, but that's entirely up to the panel, but if that is the case, this is not that case where we need to revisit felony murder. nor is it that case where 33E applies. The reasons being are set out in graphic detail, and I won't go into all the details again, in the Commonwealth's brief regarding the extent of the injuries to this man. And I would also point out not just the types of injuries, and that's clear for the court to read, but the fact that the man apparently, and it's a reasonable inference, was restrained by very large zip ties, a number of which bloodied zip ties were found in the apartment where the unarmed robbery and then murder occurred. And these zip ties, a number of which were positive for his DNA. But what I would also point out, when I said Iago, I wasn't being facetious there. You look at Mr. Morin, and we're hearing that Mr. Morin, well, how much did he really have to do with all of this? And I would suggest to this court that the evidence before the lower court was that he was the instigator. He is not an innocent party here. He's the man who realized the problems with the supply train, the drug supply. He's the man who tried to get Nelson Mello, a man he needed to convince. Why? Because Nelson Mello was his only connection to Aaron Fleming, the victim. The only connection. Because Aaron Morin and Chad Fleming, my apologies, were not known to each other. The middleman, the key man, was Nelson Mello. So what does the defendant, what does Mr. Morin do regarding Nelson Mello? He starts whispering in his ear about how Mr. Fleming is now his competitor. There is evidence before the court from Kendra Mello stating that Aaron Morin is talking to Nelson about, well, he's a competitor. And Kendra doesn't believe it either. Neither Nelson nor Kendra believe it until Aaron Morin finds himself a third party who will corroborate it. So now, Nelson Mello, a man who, as described in the defendant's brief, is a fellow on steroids, who's injecting himself, who is taking the drugs, the Percocets, who is unbalanced, is now being encouraged by Aaron Morin to find Chad Fleming's his enemy. Further, what does Mr. Morin then do? Well, he's calling up his friends after he meets with Mr. Mello. He's calling up his friends and saying, meet me at the TGIF. Meet me there. I want to talk to you about something. He calls up Mr. Madison. He's good. One gentleman was at the TGIF. The other gentleman, Bradley George, I want to say, was at the Houseware Pizza. And he says, come on. Why don't you, particularly with Madison, you owe me thousands of dollars. I'm going to forgive you thousands of dollars, and I'm going to give you $3,000 more. And I want you to get involved in what's going to be a simple robbery where we're going to go after my connect. In any event, there are more details, but I won't bore the court. The point is, he's not an innocent man. This is not a case to revisit felony murder, and with all due respect, it's not a case for 33E either, and we'd ask the court to affirm the jury's verdict.
The one part of this case that I really couldn't figure is, it wasn't quite clear that what happened had any connection to what the plan was. I mean, I thought the plan was basically you bring in a few big guys,
Yep.
they find them together, you say, we're going to rip you off, and they walk away.
Right.
But that's not apparently how it played out. Was there any indication that they had gotten the money?
The indication was that they left with something, yes, that they did find that they left with something, whether it was the money or the Percocets, because they had both. It was not clear. But the thing I think that answers your question is this. They expected, there's at one point where you've got Aaron Morin talking to Madison, and he's saying, this kid's going to, I'm sorry, I don't know if he said shit his pants or something, but he's going to be scared to death when he sees the big guys, coming in. And then at a later date, after things go awry, you have Aaron Morin on the phone saying to Kendra Mello, that kid was tough. The reasonable inference being Chad Fleming was no pushover. And I think that's what happened in this case, Your Honor.
Now, was there any charge here of murder by a deliberate premeditation or extreme atrocity or cruelty? There was, so that was presented.
That was presented.
And without felony murder, if indeed he was alive and would not have died and was strangled, you probably would not get a murder conviction.
It may be in this case, but again, and this goes back to the comments about the fairness of the jury instructions, His Honor very fairly set out to the jury, accurately, instructed them as to what had to happen. He did, Aaron Morin, he had to have more than presence at the scene. He had to have done an overt act that would put him into the joint venture that led to the felony murder. But it was not necessary that he be standing there and killing the man in order for him
Right,
to.
I understand that. But but that's because of the felony murder rule.
Correct.
Speaking of the felony murder rule, has any state which knocked it, which abolished it, anything but prospectively?
Oh, that I don't know, Your Honor. I apologize. The states, and as I would cite to the amicus brief, which was very helpful in that regard, there's only 3 that have abolished it, but I honestly do not know if it was prospective or retroactive. If there's nothing further, thank you,
Okay,
Your Honor.
thank you.